The Congressional hearing room felt less like a forum for deliberation and more like a sealed chamber under rising pressure, the kind where reputations are tested and political narratives either hold or collapse. Governor Greg Abbott sat at the witness table with the practiced composure of a man accustomed to deference. Decades in Texas politics had trained him well for moments like this. His wheelchair was positioned squarely at center frame, a familiar visual for cameras that had followed him through countless press conferences and legislative announcements. The microphones were angled just right, the lighting optimized, the setting carefully controlled. Abbott leaned forward with the confidence of someone who believed he understood the terrain better than anyone else in the room. He was there to sell the Community Protection Act, a bill his administration had been promoting as a decisive response to rising public anxiety around crime and disorder. In Texas media appearances, the legislation had been framed as a common-sense solution, a necessary recalibration of law enforcement authority in an era of unrest. Abbott's opening statement reflected that framing perfectly. It was polished, disciplined, and unmistakably familiar. He spoke of embattled police officers, of neighborhoods living in fear, of a state under pressure from forces that threatened order and safety. His tone carried the cadence of law and order politics refined over years, mixing Texas bravado with the gravity of executive authority. We're simply giving law enforcement the tools they need to keep our communities safe, Abbott declared, his voice steady and confident. He spoke as though the matter were self-evident, as though the only reasonable response to fear was expanded power, broader discretion, and fewer constraints. Heads nodded around the room, some members glanced at their phones. Others whispered to aides. On the surface, it sounded like just another hearing, just another governor asking for federal support to implement a state initiative framed as public safety. Several seats down the table, Representative Jasmine Crockett listened without moving. Unlike many of her colleagues, she wasn't multitasking or performing attentiveness for the cameras. Her posture was still, deliberate, almost surgical. Her pen moved steadily across her notepad, not recording Abbott's talking points so much as organizing a case against them. At 42, the Congresswoman from Dallas had built her reputation on preparation and precision. Before arriving in Congress, she had spent years as a civil rights attorney, the kind who read every footnote, every clause, every buried definition that could change the meaning of a law in practice. In the 72 hours leading up to the hearing, Crockett had done what she always did when stakes were high. She read the Community Protection Act line by line. She cross-referenced it with Supreme Court precedent. She consulted constitutional scholars and civil liberties experts. She examined how similar statutes had been enforced in other states, not as abstract policy experiments, but as real laws applied to real people. She wasn't interested in what Abbott said the bill was meant to do. She was interested in what it actually did. Abbott continued painting a picture of Texas under siege. He cited crime statistics selectively, emphasized isolated incidents, and leaned heavily on the language of urgency. Police departments, he argued, were overwhelmed. Communities were losing confidence. The state needed stronger mechanisms to intervene before disruption turned into chaos. The solution, he insisted, was straightforward. Expand law enforcement authority, create new categories of prohibited conduct, and empower prosecutors to act decisively. It was a narrative carefully designed to sound reasonable, even reassuring. Who, after all, would object to keeping people safe? But Crockett had read beyond the rhetoric. She had studied sections 7 through 12 of the bill, the portions rarely mentioned in press releases or stump speeches. Those sections contained language so broad and elastic that it effectively erased the line between criminal conduct and constitutionally protected activity. Peaceful protest could become a felony. Online organizing could be construed as conspiracy. Law enforcement would be granted preemptive authority to shut down gatherings based not on what people had done, but on what officers believed they might do. It was the kind of legislative overreach that often went unnoticed until it was enforced. When the committee chairman glanced down at his agenda and announced that Representative Crockett was recognized for 5 minutes of questioning, the atmosphere in the room shifted perceptibly. Journalists straightened in their seats. Camera operators adjusted their framing. Staffers along the walls stopped their quiet conversations. Those familiar with Crockett's approach understood that her 5 minutes rarely stayed confined to the clock and almost never unfolded the way witnesses expected. Crockett adjusted her microphone with deliberate calm. She made eye contact with Abbott before speaking, a small but telling gesture that signaled this would not be a performative exchange. "Thank you, Mr. Chairman," she began, her voice clear and controlled. "Governor Abbott, I appreciate you taking the time to appear before this committee to discuss the Community Protection Act." Her tone was measured, respectful, almost disarming. "Before we get into specifics," she continued, "I want to make sure I understand your central argument. You're telling us that this bill is necessary to keep Texans safe. Is that accurate?" Abbott nodded without hesitation. "That's exactly right, Congresswoman. Public safety is my top priority, and this legislation gives law enforcement the resources and authority they need to protect our communities." Crockett nodded slowly, as though weighing his words. "And you've said several times in your testimony that this bill is about fighting crime, protecting families, and supporting police officers. Those are goals I think everyone here agrees are important, correct?" Abbott smiled, sensing alignment. "I'm glad we can find common ground, Representative." It was the opening Crockett had been waiting for. "Common ground is always a good place to start," she said, her voice still calm but now carrying a sharper edge. "So let's talk about what this bill actually does, not the talking points, not the press releases, but the language you're asking Congress to support and federally fund." She lifted a thick, heavily tabbed copy of the legislation, its margins filled with handwritten notes. Section 7 of the Community Protection Act creates a new offense called organized disruption. "Governor, can you explain to the committee what qualifies as organized disruption under this bill?" Abbott shifted slightly but maintained his composure. "That provision is intended to address situations where groups intentionally disrupt public order, block roadways, or interfere with lawful commerce. It's common sense public safety legislation." Crockett flipped to a marked page. "Let me read the actual language," she said, "because I think the American people deserve to hear it." She read aloud, carefully and deliberately. "Organized disruption shall be defined as any gathering of 3 or more persons that creates or has the potential to create interference with normal activities, traffic flow, business operations, or public services." She looked up. "Governor, under this definition, could a group of college students protesting tuition increases on a public sidewalk be charged with organized disruption? Could parents gathering outside a school board meeting be arrested? Could workers picketing for better wages be prosecuted?" Abbott's smile tightened. "Those are hypothetical scenarios." "They're not hypothetical," Crockett replied smoothly. "They're routine exercises of First Amendment rights, and under your bill they become crimes." A murmur rippled through the room. Committee members began flipping through their copies of the bill. Abbott attempted to reframe the issue, but Crockett didn't give him space. Section 9, she continued, authorizes law enforcement to disperse any gathering they deem to have disruptive potential before any disruption occurs. That's prior restraint. The Supreme Court has been clear for decades that the government cannot suppress speech based on speculation. Abbott leaned forward. "Public safety sometimes requires. Public safety does not override the Constitution." Crockett cut in, "And that's exactly what this bill attempts to do." She moved on to Section 11, which criminalized the use of electronic communication to coordinate activities that might result in disruption. "Governor, you've made it illegal to use social media to organize protest. You've turned democratic participation into criminal evidence." Abbott claimed safeguards existed. Crockett demanded he point to them. He couldn't. "I've read this bill front to back," she said. "So have constitutional law professors from UT, SMU, and Baylor. Every one of them said the same thing. This bill would not survive its first constitutional challenge." When Abbott attempted to patronize her by questioning her experience, Crockett stopped him cold. She reminded the room of her 15 years as a civil rights attorney and her experience defending protesters against unconstitutional laws. The silence that followed was total. She then walked the committee through real-world examples from other states where similar laws had been used to arrest grandmothers, environmental activists, disability rights advocates. Finally, she reached Section 12, which imposed civil liability on anyone who supported protest activity. If a church hands out water, they can be sued, she said. If a business lets people use a bathroom, they can be liable. If a lawyer offers legal advice, they can be punished. She leaned forward. This isn't public safety. This is authoritarianism. The word landed hard. Abbott tried to recover, but Crockett pressed further, asking whether the Selma marchers could have been arrested under his bill. Abbott hesitated. Crockett answered for him, walking through each section that would have criminalized the civil rights movement. By the time she held up the Constitution and accused the bill of abridging rights on every page, Abbott's narrative had collapsed entirely. When Crockett moved to table federal support pending constitutional review, the political damage was irreversible.